Good morning and welcome to today's coffee break seminar, which we have trailed as a quick paddle into the murky legal waters of riparian rights. My name is Elaine Brailsford and I'm joined by my colleague Gina Johnson, and we're both members of the Rural Disputes team at Sheppard and Wedderburn. Riparian rights are a rather complicated and sometimes confusing area of law, but one in which both Gina and I have recent litigation experience. And it's an area of increasing focus for landowners and developers alike. It's also an area where there is likely to be possible reform in the future. So first of all, over to Gina to tell us just what are riparian rights.
Thanks, Elaine. In very simple terms, riparian rights are the rights held by owners of land over which a river flows. The law in this area is very old, and it's based on a number of very old legal principles stemming right back to the law of ancient Rome. Now, as we all know, us lawyers love our Latin, and even the word riparian itself comes from a Latin word, riparius, which means relating to a river bank. A lot of us will probably think about riparian rights as rights of ownership of water, but that's not, however, accurate. As a matter of law, running water in Scotland is in fact ownerless, and the idea of running water being ownerless stems again back to principles of Roman law. Running water was seen as ownerless in just the same way as the air and light were seen as ownerless. They were all seen as being available for everyone to use. So whilst running water is ownerless, a riparian owner is, however, able to make use of the running water as it passes through the land in their ownership. Now, even in Roman times, it was recognised that the rights of riparian owners had to be regulated in some way in order to protect the rights of others. And that might be the rights of owners across the river who owned the opposite side of the river bank, if that was in separate ownership, or owners of the water downstream.
But the law is a bit murky. It's not statute-based. There's no act of parliament for an owner or a developer to look to for the rules or to answer queries they might have about their rights and obligations. And as Gina has said, the law is based on Roman law principles, which have been developed through the centuries by case law. And the vast majority of the case law is very old indeed, dating back to the 17th and 19th centuries. Now, a significant amount of this case law developed following on litigation during the Industrial Revolution, when water started to become used in industrialised quantities. And that often led to disputes between landowners, given their competing interests and demands to the water that was running through their land. Depending on the context, it can be very difficult to apply these older cases, which considered things like mill lathes in the 18th century, to modern problems faced by landowners and developers today in areas such as hydropower developments. Riparian disputes are also not frequently litigated, certainly not as much as in other areas of property law, and that means that the law is not as well developed.
In modern times, the law of riparian rights also sits alongside a number of other areas of law, such as public law and various other rules and regulations. Riparian rights sits with areas of law such as planning and a sophisticated system of environmental protection surrounding water use, water abstraction and the discharge into watercourses where there are various licensing regimes in place. In Scotland, licensing is monitored by SEPA, the Scottish Environment Protection Agency. The interaction of these various laws can muddy the water at times, sorry for the pun, and it can be very difficult for landowners and developers to properly understand their legal rights and obligations amongst what is a matrix of various rules and regulations. We're all living through quite unusual times at present with the COVID-19 epidemic. And when the law was developing, they had their own epidemics of cholera and typhoid, which were spread in contaminated water. And this led to an increased focus on public safety and maintaining drinking and sewage systems. And the case law that developed was focused on protecting the property owner's domestic use and having and maintaining a safe supply of drinking water.
So it's against this background that we come to consider who holds the riparian rights. Well, the answer will depend on who owns the land over which the river runs. If a river runs solely through my land, then the river belongs to me. If a river runs through Gina's land, then through my land, and then on through someone else's land, we will each own those successive parts of the river up into the boundary of our title. and we will each have riparian rights in the river. Where the boundaries between two parcels of land is a river, there's a presumption in law that the owner of each parcel will own the alveus, another one of our little Latin words, meaning the riverbed, will own it to the midpoint. Now, this is a rebuttable presumption, which means that it can be overturned if the title contains a different provision. I actually had to advise a client not that long ago about this very point. Their neighbour on the bank opposite was fishing the river, and the assumption was that the presumption applied, but in fact, the title to the alveus was held by my client, so the neighbour had no right to fish at all. And we'll mention fishing a little bit later in this webinar.
The extent of the riparian ownership can actually be quite complicated, and that's especially so for very large estates where the ownership might be built up of various parcels of land acquired over time from different parties, or for example, where there might have been transfers of part out of the title over the years. This means that at some points in the river, the estate owners might own the full extent of the river, but at other points they may only own to the midpoint or even only the land up to the river bank, as Elaine had mentioned. The legal ownership of the property title will therefore have a significant impact on their riparian rights and obligations. Another thing worth bearing in mind is that the course of the river is likely to change or alter over the years. The scouring effect of water might erode one side of a river bank and lead to deposits of silt on other parts of the river. Over time, this can sometimes lead to quite drastic changes to the course of a river. Where a title is bound by a river, this can also lead to changes of the boundary line of the title. Again, the rules in this area are primarily based on rules of Roman law and some very old legal principles. So what are the basic riparian rights? The primary right of a riparian owner is the right of common interest in the river. So if Elaine owns land over which a river runs, which leans onto my land, we will both have rights of common interest to the river. The lower downstream owner is entitled to receive the natural flow of the river. The case law talks about the riparian owner being entitled to the natural flow, undiminished in quantity and quality, and we'll come on to discuss both of those aspects shortly, quantity and quality. As we mentioned at the very start, a riparian owner does not own the water per se, but they're entitled to use it. The case law which is developed draws a very marked distinction between consumption, which is considered a primary purpose, and consumption for secondary purposes. Primary purposes cover things like domestic purposes, drinking water for the owner of the land and their family, and water for their animals. And it also includes other domestic purposes such as cooking, washing, and brewing for domestic use. All things which would have seemed quite essential in centuries gone by, but many of which will probably seem pretty strange in the 21st century when we just turn on a tap to get our water. Secondary purposes, by contrast, are uses such as agriculture and industry. Now, if I own a stretch of river upstream from Elaine, I'm entitled to use it for primary purposes, i.e. my own domestic use and for my livestock. Then it goes without saying that at least some of the water I'll be taking out of the river. Any use, therefore, is going to mean at least some reduction to the water in the river. So this idea about Elaine being entitled to the water undiminished through the case law is not actually quite as extreme as it sounds. As a matter of law, there's an exception for me to use the water for those primary purposes, and actually I'm entitled to do so without any limit, and that might mean that I take all of the water from the river and Elaine's left with nothing. Secondary purposes, however, are a very different story, and there's competing cases of whether a riparian owner can remove water for secondary purposes like agriculture or industry at all. Some cases suggest that there's a very extreme position that no consumption for secondary purposes is allowed, whilst other case law suggests that a riparian owner can only object to water being used for secondary purposes if the use causes a material disturbance to the flow. It's considered that this requirement for a material disturbance reflects the law of Scotland. In fact, the recent litigation that Elaine and I have been involved in turned on this very question of what is a material disturbance. This is always going to be a question of fact and degree, and it depends very much on the volume of water in the river and how much is being removed.
So what does all this mean in the modern day of hydro schemes and renewable energy? Well, despite most of us in Scotland probably wishing for less rain, Scotland is uniquely fortunate for hydro generation potential. Around 85% of the UK's hydroelectric energy resources in Scotland. In recent years, smaller hydropower schemes have also become more cost effective to develop and to run. And you're more likely to see these now than you did before, when it was limited to large-scale multi-million-pound developments. Nowadays, we've got much smaller scale developments with micro and even pico hydro schemes. And this has meant that riparian rights have become a renewed focus of attention for developers and landowners alike. A landowner might think that they've obtained the necessary planning permission, they've got their licenses from SEPA, and that's all that is required. But this is not, however, the case. Hydropower schemes constitute secondary purposes. If the scheme would impact on the riparian rights of others to a material extent, a developer might find themselves at risk of court action. And this was the position in Gina and my recent case. If the scheme is solely within one title and the water returned within that title, then the scheme is unlikely to have any impact on riparian owners downstream. If, however, the scheme takes place in a stretch of river over which others hold riparian rights, the scheme may well interfere with their rights. The primary remedy for a riparian owner who's impacted is an order of interdict. That's our Scottish equivalent of an injunction. There may be an order to stop a development entirely or to restrict its use. There may also be a claim for damages, depending on the circumstances. In our recent case, the scheme took the water upstream from the pursuer's land and it returned it below the pursuer's land, thus denuding the pursuer of the full extent of water in the river at certain times of the scheme's operation. Now, the issue was, what is material interference when it comes to secondary or commercial uses? Every case is going to turn on its own facts and circumstances. In our recent case, the defender operating the scheme conceded the action against him on the door of the court, and the scheme was restricted by agreement in its operation to times when its operation would not cause material interference, as there was still sufficient flow of water left in the river at those times.
One of the other aspects of riparian rights of common interest is the right of the riparian owner to receive the water unpolluted. And this is where the idea of quality of the water, which we touched on earlier, comes from. The riparian owner is said to be entitled to receive the water in the same way bestowed by nature. Pollution in modern times is typically policed by rules of public law and by public bodies such as SEPA. Pollution of a river can, however, also be considered as part of the law of nuisance. Although there is doubt as to the level of pollution required to constitute a nuisance, it's thought that if pollution would make a river which was previously capable of being used for primary purposes like drinking water unsuitable for that purpose, that would be actionable under the law of nuisance. A riparian owner might, however, also be able to raise an action on the basis that the pollution is a breach of their right of common interest. Although the law has not been well developed in this area, there are a small number of older cases which support there being an independent right of action. This protection of the quality of the water might also be a higher standard than those recognised under either the laws of public law or under the law of nuisance. This could lead to quite a strange consequences, that an owner raising concerns with SEPA or the local authority might find that they're actually better protected through the rules of private law and under their riparian rights.
Now, we said we would touch briefly on fishing rights. Fishing rights could be a subject for discussion all on its own. But in this context, they are part of the bundle of riparian rights that come with the river. The riparian owner does not own the fish in their section of the river per se, as wild fish are ownerless until caught. However, as riparian owner, they do have the exclusive right to catch them unless they are salmon. The riparian owner does not necessarily own the salmon fishing rights to the river. That's because salmon fishing rights are part of rights originally held by the Crown. Over the centuries, many of these rights have been granted away by the Crown and are held under a separate legal title, so they do not attach to the land in the same way as trout and freshwater fishing rights do, and instead they can be held independently of the land. Where there is a separate salmon fishing right, the riparian owner must exercise their fishing rights in a way which does not cause material disturbance to the owner of the salmon fishing rights. Salmon fishing rights also carry with them the right to fish for trout and other freshwater fish, and also the right to access to the river for the purpose of exercising their right to fish.
The final area which Elaine and I wanted to touch on briefly today was the possibility of reform of the law in this area. A number of other jurisdictions have reformed their rules on private water law rights over recent years, jurisdictions like South Africa and Norway. And as we've seen, the law arising as it does out of the Industrial Revolution, where very different considerations apply, can make it very difficult to apply and understand those rules in a modern context and to modern problems. In 2014, the Land Reform Review Group identified private law water rights as an area which should be considered for possible legal reform in the future. Any process of reform in this area will obviously require discussion with landowners and other stakeholders, and there will also be various matters of public policy to be considered. So this is still very much a watch this space situation at present, but it's one to be aware of.
So that is our paddle and our coffee break over. Please do get in touch with us to discuss any of these issues, or just get in touch with us for a virtual coffee in these days of tedious lockdown. Our next webinar is next Wednesday, the 24th of June, when Stephanie Hepburn and I will be talking about right to roam and trespass. So I hope you'll join us then. Also, if you've missed any of our webinars in this series, they're all recorded, so you'll be able to watch them. The link will be the same as you have accessed for this webinar, but if you have any difficulties, please just get in touch. In the meantime, thank you all very much for tuning in.